He shouldn't have any access to any of this, okay? His email account should have had its password changed a long time ago. You don't get to touch the Dropbox account. You're kicked off the server. You're done. He is disqualified. He's unconstitutionally appointed and funded, and disclosure of the final report would be an affront to this court. Here it is again, and it would be a contumacious action.
So if they're not allowed to issue the report, that's what it would be. Because he was thrown off the case in disgrace. Why should he be allowed to write a fake report? It'll only be a fake report.
Right. Jack Smith, the illegitimate so-called prosecutor who had his case dismissed in Florida, loses again. Man, this guy must be tired of losing because there is so much losing happening. But when you're a loser, maybe you start to enjoy it. We're going to go through several things today, including Judge Cannon's brilliant order that looks like this, where she is delaying temporarily the release of Jack Smith's disgusting book report. Now that he's not going to get any convictions because the January 6th case was voluntarily dismissed by him since Trump is coming into the presidency again, and the Florida classified documents case, which was dismissed because he's illegitimate, he was going to try to salvage his reputation and to deliver a big, disgusting dossier that he could just drop on everybody's desks right around the inauguration that would show that Trump's a bad person, and the media could lap it up for a week or two and sour what is going to be America's greatest golden age in modern history. But now he's going to be delayed from doing that. And the reason being is because Trump submitted this to Judge Cannon, Trump's emergency motion to preclude the government from releasing illegitimate Jack's special counsel's report. Trump did not write this per se, but he's joining it in spirit. And the person who did draft this, because Trump's case has already been dismissed here. Remember, we're in the Southern District of Florida. Trump's case is gone because Jack Smith was illegally appointed to prosecute him. And Walt Nada and Carlos de Oliveira were still co-defendants who still have their case moving forward against them. So here is what they are filing, and they're joined by their attorney, Stanley Woodward, who we've talked a lot about here, who's representing Walt Nada. Now, they are writing this. Listen, despite this court's concluding that Jack Smith is unconstitutionally appointed and funded, and despite ongoing proceedings against Walt and Carlos, which should be gone, right? If Jack is illegal, they should be gone. Special counsel Smith, in defiance of this court's ruling, is determined to have the final word by pushing forward with his, quote, final report that Merrick Garland is certainly going to release and make public immediately. Now, these two guys here, who are still defendants in this case because their case has not been dismissed yet, these defendants will suffer harm. They're going to be civilian casualties in this war between Jack Smith and Trump, and they're impermissible and contumacious. Oh, there's your $3 word of the day. Utilization of political lawfare to include a release of an unauthorized report. The final report and the materials on which Jack Smith relies are disqualified. He shouldn't have any access to any of this, okay? His email account should have had its password changed a long time ago. You don't get to touch the Dropbox account. You're kicked off the server. You're done. You're not a real boy. You don't get to do this work anymore. But for some reason, he was. The DOJ just allowed him to do it, and he was still prosecuting over in the J6 jurisdiction. Making his attempt to share these materials highly improper. This court and their authority to regulate the participants and the attorneys in this matter and to preserve the authority of your orders, like Judge, if you're saying Jack Smith is illegal and illegitimate, well, he can't just do whatever he wants then. I mean, does your word mean anything? Or can he just do whatever he wants? And you say he was illegally appointed and then illegally appropriated a bunch of money, but now he's taking that money and he's just going to write and release reports. Like, are you going to sit there and take that, Judge? The court's control of the proceedings compels this court to preclude this imminent act of defiance of this court's authority by the government. Judge, you better not allow that to happen, man. And so Trump requests an immediate hearing on this motion, and we're going to establish the impropriety of this unchecked release. We're going to tell you about the prejudice of this report. And even if any version of this report is transmitted and released, I don't care if it's done, I don't care if it's in draft form, I don't care what they're doing. These defendants maintain no such release would be warranted at all, and we're at least entitled to a hearing on this. And if they want to release it, they should explain why. They request that this court enter an order stopping Jack Smith from transmitting the final report or anything else to anybody. Do not edit it, do not access materials on which the report relies until this court resolves this. So you're frozen. You don't get to run off and publish an illegal report. The final report, Your Honor, promises to be a one-sided, slanted report, relying nearly exclusively on evidence presented to a grand jury and subject to all requisite protections. You can't just share what happens in those proceedings. These are secret proceedings, which is no known to Smith only as a result of his unconstitutional appointment. He should have never been privy to that information in the first place. It's going to serve a single purpose: to convince the public that everyone Smith charged is guilty of crimes. But Nada and De Oliveira's criminal cases are not over. The appeal of this court's dismissal order by Jack Smith is still pending. Now, Jack's team is not on that. They filed that motion to withdraw, and now they've handed that off to the Southern District of Florida. The government notably continued briefing the appeal, even following the dismissal of the appeal as to Trump. And so there remains the threat of future proceedings for these two, and those proceedings will be prejudiced by the dissemination of the final report. So if you let the report go public, it's going to impact the jury pool, and these two guys have open cases, so you can't let it out. As the government knows, the continued operation of the protective order in this case will make the one-sided, impermissible final report even more unfairly prejudicial. The defendants, our clients here, are strictly precluded from refuting the report. The final report is meant to serve as a government verdict against them, and that is against all criminal norms and the Constitution. Now, critically, Trump and his co-defendants, the government never sought a stay of this court's rulings. As to the impermissibility of his appointment, the government never sought clarification of the prohibition against disclosing things. And so, given the invalidity of his status under the Constitution, the invalidly appointed special counsel lacks authority to write a report, to file a report, to share information about the report, or to issue a report at all. He is illegal. The filing of a report by an unauthorized person is clearly improper, and it's going to harm the pending criminal proceedings that are now on appeal because of Jack Smith. So the prosecutor cannot be allowed to release a big smear campaign while two other individuals are still being prosecuted. Issues of disclosure and the use of materials by the government are matters that this court assumes jurisdiction over, and the filing of the final report by an illegal counsel who's unauthorized would necessarily implicate the same unresolved 4th, 5th, 6th Amendment issues, attorney-client issues, that Jack Smith lost when we found he had no position or authority to take a role in the government at all. And the final report would also be an abuse of constitutional and privileged powers. Sidestepping by the government to get around those things would prejudice and disparage the defense. It would taint the jury pool. It would render the defense case unreasonably difficult for us to even defend. And this court doesn't need to tolerate this crap, Your Honor. It's unconstitutional, and it violates your local rules. And it certainly does not need to tolerate that prejudice when it stems directly from the unconstitutionally funded acts of an unconstitutionally appointed individual, let's go, whose purported authority stems directly from unlawful regulations. 3 strikes, Jack! The final report itself is also inconsistent with other constitutional, statutory, and regulatory provisions, illustrating why it cannot be released. Its release would directly infringe on Walt's and De Oliveira's rights in many ways. This court should prevent that infringement and stop Merrick Garland, the U.S. Department AG, and Jack Smith, illegal, and their officers from issuing a final report. Cannot be allowed to happen. We need this relief right now because they're going to issue a final report in the next few days. And let's go through this in finer detail. They obliterate Jack Smith. Trump's defense explains. On November 18th, Merrick Garland appointed Jack Smith. He said, "It's an attorney from outside the government going to come in and do this." But guess what? Jack Smith was not nominated by the president. He was not confirmed by the president or the Senate at all. We filed a motion to dismiss, and guess what? The court correctly determined Jack Smith is illegal. He's not a real boy at all. They said that Smith is at least an inferior officer within the meaning of the Appointments Clause, and because there was no law authorizing Smith's appointment, he could not be funded by indefinite appropriations. And the statutes that they pointed to do not give Merrick Garland the authority to appoint somebody like Jack Smith. So you lose. Smith filed his notice of appeal, and that went up to the 11th Circuit, and then the 11th Circuit dismissed that appeal because Jack Smith said, "I want to dismiss it against Trump," right? Because Trump is the president now. So the DOJ is leaving their appeal behind for Trump, but still moving forward against the other two. Now, the appeal as to Walt and to Carlos is still pending. Jack is trying to relinquish control. He handed this case off to the Southern District of Florida, as we mentioned. So he filed a motion to withdraw, got off that case, and so Jack Smith is not even on the appellate case at all now. Now, the report is coming out any minute. Despite losing in court twice and having no valid appointment, Jack Smith is determined to continue to litigate this case in the court of public opinion. In early December, news reports indicate that he's going to release a report summarizing the result of his investigation. Fox News talked about it. In response, counsel for President Trump reached out to J.P. Cooney, who is an illegitimate prosecutor prosecutor along with Jack. He might be a legitimate actual prosecutor, but if you're on Jack's team, you're all illegitimate as far as I'm concerned, because you all got paid from the same illegal appropriations. Counsel were told the special counsel's office would afford the meager courtesy of allowing a hard copy review of the report with comments due before 2 p.m. on January 6th. Counsel were not permitted to bring electronic devices into the room. It's like a skiff. The office declined to make the report available to out-of-town Florida counsel. You had to come to D.C. There's a snowstorm coming. Come look at it at my office. Counsel for De Oliveira was able to review the report on January 4th. D.C. counsel did so for Nada on Saturday the 5th. We've had limited access to review the draft report, and so somebody has seen it. A couple people have. But Garland is going to release it. The final report will go to Garland, who can then authorize the public release. There's every reason to believe that he's going to do so as quickly as possible before Trump comes in 13 days. First, someone said he's opted to release the reports from 2 other special counsels, and so why wouldn't he release Smith's? The review deadline that Jack gave to the defense attorneys reflects that public release is imminent, and less imminent now, as we'll see. So they say the time frame above shows that a relief is needed right now. Smith gave Trump and the defendants a very brief window to review that, and that expires this week. So it's fair to assume that once the window expires, the report will be released thereafter. That's within 7 days of this motion, so we have to go fast, Your Honor. What we're asking right now is absolutely necessary. We need an injunction. Stop Jack Smith from releasing the report. There was an order from you disqualifying him, and there's another local rule governing the release of info. In these principles is a Fifth Amendment right to a fair trial. This case is still very much pending against 2 other people, and Jack Smith is now trying to try this case in public after he's already been found to have been acting unlawfully and unconstitutionally, Your Honor. He's trying to take advantage of this. This would be highly prejudicial to everybody. Stopping the release of the report is necessary to protect the people here. Releasing the report is also improper because this is not Smith's case anymore. He has been disqualified by a court of law. He's now acting as a rogue actor with a personal and political vendetta against the defendants, and he's still taking money from the government. It's fraud and illegal, and he should be prosecuted, and everybody else in his office under RICO for continuing this conspiracy and absconding with government funds. Allowing him to release materials and information to the public does great harm to these 2 co-defendants and to Trump, who remain at risk of prosecution. In any other case, this court would have the authority to stop him. The same is true here. Our system simply does not allow a disqualified prosecutor to withdraw from an unlawful appeal, only then to embark on a media mudslinging tour through the issuance of a highly detailed, one-sided press release that explains what happened in the indictment and their own theory. Smith's latest tactic to release the report after being removed from the case reflects his ongoing and continuous effort to violate your order, Judge. In this instance, there have been severe implications for our 2 people. The court has previously recognized that Jack Smith is a hack. He evades court rules, selectively communicates and leaks materials to the public that are privileged, and the former special counsel's approach is anything but objective. The integrity of the future proceedings are threatened by the release of this report. And finally, you should stop this, because this court has already determined, which is binding, by the way, that Jack is unconstitutional, and he's got unconstitutional money. Issuing the final report makes the constitutional error of his illegal appointment even worse. Any of these reasons should justify an injunction or at least give us a hearing. The final report also threatens the future proceedings. Local rules in the Southern District of Florida say you cannot release information that is going to be a problem for imminent legal cases. Any reasonable person would expect the report would destroy these guys' chance at a fair trial. That's an understatement, they say. The final report would not just be disseminated by means of publication, it would be shared widely. Media all over the place would push it to millions of people's phones. Everybody, including talking heads, would give their reactions and their legal analysis, in quotes, I know he's not talking about us here, on events about which they in fact know only Smith's position, as portrayed by an illegal disqualified counsel. It's gonna be all over the place. The mass media will become a mass microphone for Jack Smith and his political allies, left to report only the narrative that were advanced by him, even though Jack Smith shouldn't have access to any of this. The news media is already excited as heck about this. Look, they say, article, ABC News, CNN, Newsweek's on it. This report's coming out any minute now. All of this prejudice would occur in the face of additional litigation. We know that we should have an adversarial system, but our defendants should not have unwarranted prejudice brought against him. Jack Smith is trying to exploit his unconstitutional appointment. He got appointed, took a bunch of information illegally and illegitimately, used investigators and FBI agents and assistant U.S. attorneys and other people who are prosecuting Trump. Then he's going to gobble all of that up, cobble it together, and write a report and be able to release that. All of the innards of that report were illegally gained, ill-gotten. That's what he's trying to do here. He's going to try his case in the press. He's going to taint the jury pool. He's going to taint the legal soundness of this court's decisions. So that's even worse for you, Judge Cannon. The Supreme Court has ruled that no one is to be punished for a crime without a change fairly made and fairly tried in public. And what Jack is trying to do, free of public prejudice, Jack is trying to try this case in public. Release of the report would plainly and obviously interfere with a fair trial. The report involves one-sided discussions, and it shows that it would be inflammatory. Throughout this litigation, the government has tied Nada and Walt and Carlos back over to Trump, calling him co-conspirators and more. The political motivations here cannot be overlooked. Jack Smith is rushing to release a final report right before there's a change in control of the executive branch. He and his allies, of course, are disappointed that his appointment was deemed unlawful and that Trump won. That, however, is not a basis to deny due process of law, and the timing of Smith's actions reveal what they're trying to do. This court should function independently of politics. Now, political considerations certainly do not justify the release of evidence that's already not been made public. The final report contains a bunch of evidence, grand jury materials that's already prohibited from being disclosed. They're entitled to the utmost secrecy. Supreme Court has said that. You can't release that stuff. Protecting these grand jury materials protect the integrity of the jury, and they also protect our defendants' due process rights. And so even if Smith once properly had access to the materials, he is no longer permitted to access them. Now, he cannot disclose them, so he cannot write about it. Smith has proposed redacting direct quotes from the grand jury, but he's not proposed redacting information provided to the grand jury in response to a subpoena. This illustrates the need for a hearing, Your Honor. A hearing is warranted because Smith's actions and redaction proposals, they haven't invited any other further redactions, and so we need to discuss this. What should remain sealed and what should not remain sealed? And it's going to take a lot of time to have that conversation. We got to go line by line, whatever in his report, line by line. And that's going to take a lot of time. Certainly a lot longer than 13 days. And then once Trump comes in, there is no more report. This illustrates the need for a hearing because they are not ultimately in charge of what is redacted. That responsibility lies with Garland. This court should hold a hearing to determine what content must be blocked. There are several concrete ways where the report and its release, how it will impact the defense, Fourth Amendment, constitutional rights, and more. The imminent release of the report is a violation of many things, and so they cannot lawfully issue it. His attempt to do so is ultra-virus, out of bounds. Your Honor, your decision that Jack Smith is not a real boy is binding. Accordingly, the continued funding of Jack's activities and his office violates the Constitution. It's binding here, but they continue to spend our money. Because Smith is unconstitutionally appointed, an injunction barring the release of the report is valid. The appointment order is void. Smith is not the special counsel, and he cannot use the information in the report. And they continue. By issuing the report, he is unlawfully acting as a prosecutorial authority, and he is not. The final report's transmission to Garland and presumed release, again, is him acting unlawfully as a super prosecutor. There are significant problems with separation of power here, and he's filled with bias, prejudice, and sensationalism. They continue. They're also using illegal money. For many of the same reasons, the appropriations clause is a problem. He's paying his prosecutors to write this report. There's also every indication that they're going to issue their report during this transition. The Transition Act says you can't do that. Disruption is a constitutional issue. Release of the report will disrupt the president's ability to govern once he takes office. It's going to cause public stigma and opprobrium. And so such a burden must not be imposed, especially once a prosecutor has already been deemed unlawful by an Article III court like you. He also can't release this under his own regulations. And so, Cannon, you have the ability to issue relief here. You can grant an injunction. The All Writs Act allows you to do it. You have ancillary jurisdiction. District courts can issue injunctions, and that's what we're asking you to do here. So they tell us the impending issuance of the final report is a direct violation of what you said, Judge Cannon. He is disqualified. He's unconstitutionally appointed and funded, and disclosure of the final report would be an affront to this court. Here it is again. And it would be a contumacious action and is an improper attempt to circumvent the court's authority and to prosecute in the court of public opinion. Jack's use of these materials violates the Constitution. The protective order still applies to these defendants who are still being prosecuted. And so by placing itself above the court, Jack thinks he can just do whatever he wants. He can release materials from grand jury proceedings. He can come in, steal all of this evidence with his illegal appointment, and then just release it to the public. For those reasons, Walt and Carlos respectfully ask that this judge issue an order barring the United States and its officers, not just Jack Smith, but also Garland and the DOJ and the rest of them who haven't resigned in disgrace yet, from releasing this. And they also ask to issue an order to preclude Jack Smith from taking any action on this until we get a decision. We request a hearing. This is warranted. It's highly sensitive. The release of the final report implicates due process rights for everybody. We've conferred telephonically with the prosecutors. Now, to date, they have not consented to the relief requested by the motion. The government says it considers the meet and confer process to be ongoing. They don't want to answer. Do we object or not? However, Trump requested a reasonable opportunity for them to make a decision on this. They were stalling because they want to release the report before they responded to them. That's how scummy they are, just to be clear. However, defense counsel gave him enough time and they're unwilling to commit to any timelines. So therefore, they said, we'll get back to you tomorrow. They were skeptical that the judge could do this, and they wouldn't tell us how much time before it got sent to Garland. Okay, they're like, they're going to try to stop the report. They're like writing. We'll get back to you tomorrow. Tell your position tomorrow. Nope. Accordingly, because of the emergency nature of this, if they want to amend their position, we'll tell you about it, but they're just stalling. They don't have an answer for us. And so after reviewing these, we certify this is a true emergency. We need this reviewed like now, signed by Stanley Woodward, who is going into the White House to be a senior advisor to President Trump, which is going to be a nice position for him. We also have other people signing off on this: John Irving, Richard Clow, Larry Donald Morrell, who are there for these co-defendants. And this is what Trump sent to Jack Smith, or rather to Merrick Garland. Merrick Garland got this letter from Blanche Law saying, all right, Attorney General Garland, we're writing to the DOJ right now to demand that Jack Smith terminate all efforts towards the preparation and the release of the report. This one came in on January 6th. Very appropriate anniversary to send a letter. Now, as you know, courts in Florida and DC, two federal cases, have now dismissed both of Jack Smith's cases against the president. Rather than acknowledging, as he must, that Trump has been completely exonerated, Jack Smith now seeks to disseminate his final report to perpetuate his baseless accusations. Now, consistent with the bad faith crusade that Smith executed on behalf of you, Merrick, and the Biden-Harris administration from the moment he was appointed, we were only permitted to review the draft report of this report in person in DC, including the prohibitions on any electronic devices inside a room where the draft was. Smith's team likewise demanded, in advance of any review, that we delete prior discovery productions, preventing us from reviewing any of those underlying documents that are cited in the draft report. Wow, that is scandalous. Delete all your evidence, and then we'll show you what we put in the report so you can't corroborate what we put in our fake hack report? They are so corrupt. Nevertheless, it's clear, as has been the case with so many other actions of Smith and his staff, the draft report merely continues the politically motivated attack, and his continued preparation of the report would be both imprudent and unlawful. Merrick, you cannot release this report there, buddy boy. They say, first, Smith, you lack the authority under the Constitution to issue the report. You're not validly appointed. You've stolen $20 million. The preparation and the release of this report violates the Constitution, and the draft report violates fundamental norms regarding the presumption of innocence. You're trying to impugn these two people, calling them co-conspirators. Also, preparing a report and releasing it to the public would violate the Presidential Transition Act. The act prohibits all officers from impeding the transition. And finally, the release of this report that is being prepared by this out-of-control private citizen unconstitutionally posing as a prosecutor would be nothing more than a lawless political stunt designed to politically harm President Trump and justify the huge sums of taxpayer money that Jack Smith unconstitutionally spent on his failed and dismissed cases. This is like, you're tap dancing and tiptoeing around on a criminal line here, guys. Under such circumstances, Smith's report is obviously not in the public interest, and that's because Trump won a commanding victory. And because Smith has proposed an unlawful, illegal course of action, Merrick, you must countermand his plan and remove him promptly. If Jack Smith is not removed, then the handling of his report should be deferred to Trump and his incoming incoming Attorney General, consistent with the will of the people. And you should disagree with the position set forth below. If you disagree, we respectfully request that before you release this report, you tell us so we can pursue an injunction so that the people are not harmed by the weaponization of justice system against them. So, Merrick, just to be clear, in case you were unfamiliar, you know the history of this unethical election interference. You appointed him. You started it. This letter is covering some of his most recent problems. During the week of December 9th, just not long ago, we learned from members of the media that he's preparing a report. We were surprised to learn of the plan because Smith insisted that his work was not concluded. But now he's going to release a report. So that's curious. We're just noting. Then on December 11th, we contacted a supervisor to say, can we see your report? Initially, they said, yeah, you can only access a draft in DC between the 23rd and the 29th, the week of the Christmas. So like leave your family to come see it if you want to. We would only be permitted to take handwritten notes, and any comments or objections would have to be submitted in writing by the close of December 29th. Aside from all counsel living outside DC and planning on spending time with family, as Smith and his team knew, Smith's proposal afforded zero opportunity for Trump to assist counsel in reviewing any of this. Apparently working under a self-imposed deadline, Smith's team informed us implausibly that permitting the defense to review his unlawful draft during the first week of January would be too late to allow us to complete our work because they have to release it. Then Smith walked back those now clearly false claims and allowed us to review those the first week of January. But he still didn't allow us to use the internet or any of those other things, even though he's the office that leaks everything. But we know if this report is released, it violates the law. He is already illegally appointed and appropriated. He took money and funding for an improper mission. He was never confirmed by the Senate. And so everything else that has come from that is in furtherance of a masquerade. He lacks authority to expend any funds to prepare or to issue a report. He cannot go to Kinko's to print it out. Your credit card is declined. You're an illegitimate boy. Preparation and release of a report would also be improper under the regulations. Now, his representation that he dismissed this prosecution doesn't mean he can now turn around and publish whatever the hell he wants. The plain implication is that it was concluded. It's reached its conclusion. We don't need a giant multi-page smear spread around all over the place. Public release of the report would also disrupt the transition. Congress passed the Presidential Transition Act to stop this stuff from happening, and creating and releasing a prejudicial report would create a media storm. False and unfair criticism from a hack illegal prosecutor. There are baseless attacks in there which are an obvious effort to interfere with his confirmation hearings and more. A one-sided improper report would also violate immunity principles that Jack Smith concedes exist. There's guidance from the Office of Legal Counsel. A public report by Smith would undermine that. They previously explained that public stigma and opprobrium are valid concerns, and now Jack Smith is just going to create a bunch of it with the release of his report. In sum, Trump's defense sent this to Merrick Garland. They say the same legal principles and logic that required Smith to dismiss his case requires the closing of this report. The collective application does not justify anything being done in the public interest. To the contrary, in fact, it does the opposite. You must countermand Smith's release of the report and stop it from coming out, saying the presumption of innocence is vital. These are bedrock principles. Even the Justice Manual prohibits prosecutors from publicly declaring guilt or innocence prior to a jury verdict, and that's what you're trying to do here. The draft report violates every one of these requirements. Despite Smith's decision to dismiss his cases and his complete failure to obtain a jury determination of guilt, his draft report comes out and says they all committed crimes. For example, Volume 1 of the draft report falsely asserts without any jury determination at all that President Trump and others engaged in an unprecedented criminal effort and was the head of criminal conspiracies in his STUM report and harbored a, quote, criminal design, blah, blah, blah. These false allegations have never been proven. Volume 2, without any verdict as well, says Trump violated multiple federal criminal laws. He engaged in criminal conduct, whatever. Jack's fantasy report. I'm Jack's fantasy report. Neither the Constitution nor applicable regulations or rules allow him to make that public at all. It's the role of the jury, not the prosecutor, to weigh the facts and determine guilt. That hasn't happened here. We've seen this before. Other special counsels have even agreed. For example, special counsel Hur carefully cabined his observations to what some jurors could, might, may well, or at most would likely conclude, is what they said. Might, jurors could, at most, would likely. They didn't come out and say, Trump violated multiple criminal laws. Jack Smith, psychopath, relax. At all points, Hur's focus was on what do jurors think, not on his views or his psychopathy. Likewise, Robert Mueller expressly declined to apply an approach to his report that could result in judgment judgment, and he created his report there. Now, to the extent that Smith possesses any authority to even write anything, and he doesn't, he should have applied the same principles as them. A dispassionate description of relevant facts. We don't need gratuitous commentary like what you're going to put in there. Now, there are many practical and prudent reasons to do this. In 2023, they levied extremely serious, entirely false allegations against Trump. Now, both of those cases are gone. It would be highly improper to allow cases that have been dismissed to create and disseminate yet another document that smears him, even though the cases are gone. He is the subject of an ongoing investigation, by the way, Jack. Smith's plan would be to cannibalize the executive branch, and we've already had congressional hearings where this has been a problem, and we've discussed it. Here, Smith has explained himself and sought unsuccessfully to justify his actions ad nauseum, making us puke our guts out. This has included routinely leaking sensitive details regarding the action of Smith's office. In October 24, it was leaked that Smith planned to pursue 2 cases against Trump for as long as he could. He explained that to them. A similar July report was familiar with Smith's thinking. Another example was this other article. As we learn from time to time, there's private outreach from media sources. Jack Smith is reporting to them. Many gratuitous leaks. He put stuff in his speaking indictments, held a lawful press conference in front of the national media, created an inappropriate 165-page motion for immunity determinations that was accompanied by a nearly 2,000-page appendix. He goes on psycho diatribes against Trump. Even Chutkin said, yeah, it's a little atypical here to have you so demented. Violates procedures and wants protective orders. The guy's nuts. Now, under these circumstances, there is no legitimate need for an additional report to explain anything, okay? He's explained enough, and he's illegitimate. It's all too selective. The draft report goes way beyond explaining policy decisions. It's a list of a psycho with politically motivated grievances who is just trying to rant and rave in his report. The issues of the report that we've just discussed, as we noted, immunity, irreparable damage, election interference, and more, all stacks up, and they must be stopped. Further, preparing and releasing a report would be improper because Smith has relied on numerous legal theories that are completely unprecedented. To name a few, these are cases that lack the opinion that he's relying on them for. There were numerous discovery disputes, and his draft report is selective and inaccurate, completely unfounded and illegitimate. Finally, given the status of Smith and his team, as the inauguration approaches, they cannot use any taxpayer funds. The office has spent tens of millions of dollars, all drawn from indefinite appropriations. But for the period between March 31st, 20 million and another 16 million, 32 million. It's clear, however, the total figure is going to go up dramatically. What all of this lawfare was actually worth to the public is zero. Negative, millions. We lost a lot of time, money, and the damage that they've done to the Justice Department and the institution of the law is unfathomable. Now, Smith's proposed plan for releasing a report is unlawful. It's undertaken in bad faith. It's contrary to public interest. And so Smith's conduct also raises grave concerns under Article 2. It unlawfully encroaches on executive authority of Trump. He's got a commanding national mandate. The time has come. Stop this weaponization of the justice system. No report should be prepared or released at all. Smith should be removed, including for even suggesting that course of action, given his obvious political motivations and his desire to lawfully undermine the transition. If you elect Merrick to proceed with Smith's plan, we respectfully request you notify us so we can file injunctions. And of course, they've already done that. So that is what Trump sent to Merrick Garland. And that is the motion they submitted to Judge Eileen Cannon. Now, Jack Smith and his team, they came back out and they responded. Very short response to all of this. They said, all right, listen, Your Honor, Judge Cannon, Walt and Nada, they filed an emergency motion and we're just responding. Jack's office, they write, is working to finalize a 2-volume confidential report that we're going to send to Merrick Garland. The Attorney General will decide whether any portion of the report should be released to the Republic. 1 volume pertains to this case in Florida. Now, the Attorney General has not yet determined how to handle the report volume pertaining to this case, about which the parties were conferring at the time of the defendant's filed motion, but the department can commit that the AG will not release that volume to the public, if he does at all, before Friday, January 10th at 10 a.m. And Friday, January 10th is going to be like a Black Friday, man, because they're trying to sentence Trump and trying to publicly smear him on that day. So be cognizant. The special counsel will not transmit that volume to the attorney as to the other volume. Before January 5th, the government will file a response no later than January 7th at 7 p.m. Okay, so that all came in. So reports are dropping and they're going to be bifurcating it into 2. And let's see what the judge issued in her order. Judge Eileen Cannon issues an order to stay the release of Jack Smith's illegitimate report. She writes, before the court is an emergency motion filed on on J6 by Walt and Carlos, seeks a ruling by January 10th, and is appropriately certified to prevent irreparable injury and to stop the imminent release of the public report that's prepared by Jack. This morning, they filed another motion with the Court of Appeals seeking much the same. And so the judge issued the following order. To preserve the status quo as this court awaits resolution by the 11th Circuit and to prevent irreparable harm between now and then, we now are going to order the following. Pending resolution of what's happening in the 11th Circuit, because there's a parallel issue happening there, all offices, including Attorney General Garland, Jack Smith, their officers, agents, and employees in active concert or participation are temporarily enjoined from releasing, sharing, or transmitting the final report or any drafts of the report outside the DOJ. Otherwise, releasing or conveying or sharing with anyone outside of the DOJ any information or conclusions or drafts. The order remains in effect until 3 days after resolution by the 11th Circuit unless the 11th Circuit orders otherwise. So no report coming out until the 11th Circuit resolves this. We have to double check to see what the final report includes. Does this include both volumes? Is Jack Smith going to try to distinguish this and say, well, I'll just not release the Florida report, but I'll release the report from the J6 case? Defendants Nada and De Oliveira shall promptly file a notice in this court advising of any activity by the 11th Circuit. The clerk is directed to transmit a copy of this order to the entire DOJ. And they were like just getting ready to press send. This order shall not be construed as a final order done and ordered by Judge Cannon. Jack Smith, I think, is going to be in the process right now of unbundling them just to say, oh, well, that order only applies to Florida. This is just a Florida order. Now, he should have stopped working immediately. He should have been off both cases immediately after the Florida case, but he knew he could get away with continuing to prosecute Trump in DC because it's DC. And Trump got asked about this as it was happening. This was Trump who got asked a question right as the news broke that Judge Cannon would be issuing a stay on the release of Jack Smith's report.
Thank you.
We have some breaking news. You may not be aware of this, but it looks like Cannon has blocked the DOJ from releasing the Smith's report until further court proceedings. Get your thoughts on that.
That's a big story, if I get it right. The fake witch hunt started by the DOJ, having to do with books and records, and Biden had many more, and he wasn't protected by the Presidential Records Act. I was. But all of that fake stuff that took the lives of people, I mean, literally destroyed people. People are destroyed because of what they did. But we got to be president. But Biden did it for 40 years. He did it when he was a senator. That was illegal. And they ruled it was illegal. How about that? They said it's illegal, but he's unfit to stand trial. So he can stand and be president of the United States, but the prosecutor found that he's unfit for trial. I was going to use that as a major talking point, but I never got to use it because all of a sudden I had a new candidate who was also sort of unfit to stand trial, right? So Cannon was thrown off the case. They dropped their appeal because he had no case. They
Jack
dropped
Smith was
all of
thrown
that,
off.
the lawsuits against us. They lost the lawsuit. So this is deranged Jack Smith. So he dropped the lawsuits. He was told to by the DOJ because they had no lawsuit. They lost in court in front of a very strong and a very brilliant judge. They lost
Cannon.
in court, and that pertained to other cases in other courts. So he wanted to do a report just before I take office, probably. So he'll do like a 500-page report, and it'll be a fake report, just like the investigation was a fake investigation.
Yep.
And I said, well, wait a minute. This guy was thrown off in disgrace. In disgrace. He's going back to The Hague or wherever they're going to send him because he failed so badly. Because it was a fake case against a political opponent. They thought they were going to use this to beat me. So what you're saying is, and I just heard that, they're not allowed to issue the report. So if they're not allowed to issue the report, that's the way it be. Because he was thrown off the case in disgrace. Why should he be allowed to write a fake report? It'll only be a fake report.
Right.
That's great news. Good.
Great news. Good. And you can see Trump working that out on the fly. He's like, okay, which one of my 2,000 cases am I going to talk about right now? All right, yeah, the Florida classified documents, Cannon, all right. Assembling it on the fly. And it is good news. That report is getting stalled out. Now, I have a hard time believing that we do not get a copy of that they don't leak this to somebody, that Jack Smith's team or Merrick Garland or somebody on the way out doesn't drop it. But some people are very upset about it. Liz Cheney says, as Trump is stopping the release of the imminent final report, she's very unhappy. She must be having a bad day today. She says, while Trump and Barry Loudermilk continue to spread malicious lies about my 1/6 fake select illegally constituted committee, Trump is trying to yet again hide evidence and suppress the truth. The Justice Department obtained evidence and testimony from his advisors, blah, blah, blah. He's doing what despots do, trying to conceal the truth. What happened to all your deleted interviews there, Liz Cheney? Why are we missing so many transcripts? Why is Benny Thompson begging for a pardon because he knows what they've done? The congressional report yesterday, the Dems released a terrible J6 report that's not even worth talking about, destroying Loudermilk's fraudulent and adjudicate allegations. Wrong. So she's upset. She must be really upset that Judge Cannon is not going to allow that report to come out. Liz Cheney having a tough time, and Jack Smith losing again. This is a nice meme of what Trump must be feeling like now that Jack Smith has lost again.